All right, I'm going to give you a brief overview of the area of agency law. Agency law is a very old concept. It's a foundation for employment law. It's a foundation for how businesses operate uh, based on whether you're a partnership or corporation, a limited liability company, whatever. Agency law is very important for you to understand. So I'm going to introduce the concept here first, and then we'll talk eventually about employment law. So terminology. In agency law, you have the principal and the agent, right? This is a voluntary agreement between the two. Now, this doesn't need to be a contract. Typically, it is. Remember, you can have oral or written contracts. Typically, this is a contract. It can be a situation where it's not a contract. You can have a agency relationship that is basically a gift situation where I agree to loan you my car. I know you're going downtown. Here's the car. I'm the principal. You're the agent, right? And that there are duties imposed that you need to be aware of, the duties on each party. An agency relationship you may have seen in durable powers of attorney in estate planning. If you are in the military, you may have executed a power of attorney. Those are agency where you basically designate someone as your agent to take care of your financial affairs or whatever you need to take care of when you're away. In estate planning, this is very common where you designate somebody to, control health care. These are called health care directives. You designate what kind of care you would like and who would be your agent to take care of that. These agents are referred to attorneys. In fact, it's kind of a misnomer because they don't need to be attorneys. They're just people you designate. They're agents. But this is very fundamental to employment law. And your book talks about the importance of distinguishing independent contractors. And I say IC up here. I mean independent contractor. An independent contractor from an employee. The way I do this, the way I understand this, and I think it's maybe helpful to you, realize when a principal, an employer, hires somebody, that worker can be either an independent contractor or an employee. The difference is huge because if the person's an independent contractor, first of all, you want to verify they are. And you'll see the IRS has certain criteria. The state has additional criteria. Bottom line is be very, very careful. A lot of businesses love to classify or misclassify somebody as an independent contractor when they're really an employee. And the reason is independent contractors are independent. They're liable for their own torts. Remember we talked about torts. They're liable for all of the mandatory government requirements on the minimum wage, overtime, taxes. That's all on the independent contractor, not on you. There's a number of factors you look at to determine whether a person is an independent contractor or an employee. If they're an employee, you are the employer. You're the principal. You're the employer. You're liable for the employee's torts that occur within the scope of their duties, the contracts the employee executes within the scope of their duties. You're liable for all the state and federally mandated taxes, minimum wage, overtime, all that. So as a general rule, businesses highly prefer independent contractors. Now, as I indicated, while that is the preference of most businesses, the legislative bodies recognize that, and they have made it very difficult for you to have an independent contractor. Look at the requirements under state law. I have a link on your website on this, and certainly under the IRS. Bottom line, the person truly has to be independent. They have to be independently licensed. They have to do business for other people. Big companies like Microsoft have gotten into trouble for this. They think they hire independent contractors. Most of this, you'll see under the IRS criteria, boils down to control. The more the employer controls the worker, and when I say control, I mean, provides the equipment, supervises, tells the person what to do, all that, the specifics, the more that worker is going to be found to be an employee, and then the employer is liable for everything, minimum wage, overtime, all kinds of stuff. It's very important you clarify this up front in a contract, in a written contract. So there are duties that the principal owes the agent. Among them is to provide safe working conditions, to pay the agent, etc. The agent owes the principal duties as well. Avoid conflict of interest, loyalty, all these fiduciary duties, we call them, that are important. Now, the agent can have certain authority. It can be express, written, oral, in a contract, right? It can be implied. I hire you to be my general manager of my grocery store. The implication is you're going to do a lot of things to make the business run. The one that causes the most concern that you need to be aware of is this concept of apparent authority, where the principal, the employer, goes out and leads third parties to believe that the agent, this person is your agent, and therefore the third parties may be doing business with the agent thinking that you're going to be financially responsible for whatever the agent does. This is called apparent authority. Make sure you're aware of what that is. And again, the big deal here with understanding the distinction between an independent contractor and employee is liability, especially for contracts. For torts, think about if I hire you to deliver things for me and you hit somebody in my vehicle, in the company vehicle, I'm going to be liable for that unless you're on a frolic. You'll see here there's a thing called frolic and detour unless you're so far. A detour is, I'm still liable for that. You're still going to the destination. You took a detour. But a frolic is you're doing your own thing and the agent can be liable independently for that. This idea of liability really is, the terminology is vicarious liability. I didn't do it. You did it. You're my employee. You hit somebody, or you signed a contract, or you engaged in sexual harassment, let's say. I didn't act as a reasonable person. I didn't take precautions. I didn't discipline you when it first came up. I can be held vicariously liable for that. And again, statutes can impose liability on principals, on employers for activities of the agents, of the employees. The other term to understand, this is called respondeat superior. This is let the superior respond for the bad acts of the agent, whether it's contracts or torts.